you want to interpret a constitution. So these are now 8 slides, and I'll conclude the theory part, and let's now go to how these have been applied. Now, what is fascinating is these are all theories of interpretation. The Supreme Court is faced with a problem. It has to arrive at a decision. What are the tools? What is the methods by which they arrive at this conclusion? And that you can see, I have taken about 4 or 5 cases. It's not possible in the short time to deal with number of cases. I've just taken 4 or 5 cases where I found that different theories and different doctrines have been very interestingly applied. So kindly go to the next slide. Now, if you take our constitutional history, I feel that from 50 to 67, a large part of the confrontation between the legislature and the judiciary could have been avoided if the legislature had been reasonably fair in paying not the full compensation, but at least a reasonable compensation to the persons whose property was acquired. All this tussle was to take over the property and pay virtually nothing, right up to bank nationalization. This was the entire problem between the legislature and the judiciary. But for our case, let's go to the initial cases, how different theories were applied. Now, immediately after the Constitution came into force in 1950, a series of high courts struck down zamindari legislation on the ground that the principles of compensation were completely contrary to Article 31, to 14, to 19(1)(f), and so on. What was the answer? Introduce 31A, make them agrarian reform immune from. As I said, to get over the zamindari laws being struck down, they had 31B, 9 schedule. You put the law there, no challenge from Part 3. Now, how did the court uphold it? Shankari Prasad, they said, look at 368. If you take this Shankari Prasad's case, it's a classic case of textual interpretation like A.K. Gopalan. They said go by 368. It simply says you can amend the Constitution. They don't say you can amend the Constitution except fundamental right. There's no such provision. Anything can be amended. So why not Part 3 also? That was the logic. But I have a small caveat there. If you read the judgment carefully, I have no quarrel. You want to interpret 368, interpret it literally. But when it comes to 13, when it comes to law, then you fail that no, if law is interpreted literally, fundamental rights cannot be taken away. And then you take a different interpretation. You say law means, if it's parliamentary law, it's subject to Part 3. But if it is amendment, it's constituent power and therefore not subject. So this is a kind of a basic. Now you come to, so the first case was where there was a textual interpretation going by the original, what the parties intended. And you find in the judgment reference to the overwhelming majority of, majority which the party had got. They had the mandate of the people for agrarian reform. All those things have influenced the decision in Shankari Prasad. Now, I come to Sajjan Singh, which according to me is the most important case in this question of basic structure. This is really a turning point or a tipping point, which is which has to be considered. Now, look at the scenario by 1965. You had 17 amendments in 15 years. And for the first time, 2 judges, as I said, 3:2, 2 judges, Hidayatullah and Mudholkar, they said, please pause. Please pause. Is a little interpretation enough? Hidayatullah asked the question that take away fundamental rights. He puts it very nicely. He said, are fundamental rights the playthings of the majority? That's the question he said. Then he said that, look, this power to amend may not be absolute. There may be some limitations, but he leaves it at that. And he supports the conclusion. He said, yes, 17th amendment is valid, but he flags this question on the question of the power to amend. Mudholkar is even more eloquent. He refers for the first time, and please note, this is not in Golaknath, but in Sajjan Singh for the first time, the word essential features has been used by Justice Mudholkar. And he says, can we take away everything so that what is left is not a constitution at all? And following a Pakistani Supreme Court judgment, he says essential features, maybe you cannot take it away. But then that is the view taken by Mudholkar. But for the first time, you'll find that textualism is abandoned and the other principles, as to what is the structure of the constitution, what is the intention of the makers, what are the historical background, all those things are put together in Sajjan Singh. Now, these judges don't go theory by theory, they reach a conclusion. And in that conclusion, you can analyze that this could be possible, this could possibly be the theory they applied to reach their conclusion. Now go to the next case. Next slide, please. Golaknath. Of course, Golaknath was a case where there was a 180-degree turn. From a case where power was unlimited, here it says that no part of fundamental rights can be touched. A complete 360-degree, 180-degree turn. And Subbarao judgment is interesting. Subbarao judgment says that his basis, his reasoning or the rationale for arriving at this diametrically opposite conclusion is very interesting. He says, look at 368. It says procedure for amending the constitution. So he's saying it's not a substantive source of power. This procedural article cannot take over a substantive article like 13. Very interesting way of approaching it. And he tries to trace the amending power to 248 and 97, and he says all are subject to part 13. And with this, we go to the mega case, the Mahabharata of our constitution, so to speak, which is the Kesavan Bharati case. Now, kindly see the slide carefully. I have said 7:6, or rather 6.6:6.4. As you know, Golaknath was 6:5 and this was 7:6. I say 6.6:6.4 because Justice Khanna, if you see his judgment, 60% he agrees with the majority and 40% the minority. I mean, virtually most parts he agrees with the minority, and only in the case of basic features he turns the table, and ultimately that became the decisive judgment. Now, please see the background. One way there is a very, very interesting run-up to bank nationalization, to this Kesavan Bharati case. Please look back at history. From 1967, from Golak to Kesavan Bharati, what happened? 1969, you struck down bank nationalization. 1970, pre-purses went. 1973, Bennett Coleman went. All these cases were struck down. And Justice Holmes has put it very nicely. He says that the judiciary is not immune from the hydraulic pressure of what happens around them. What is the hydraulic pressure of society? Why think of the basic structure? Till Pandit Nehru was alive, nobody thought that they will take away Article 21, they will take away 19. Nobody thought. They said, yes, we can give them unlimited power, our fundamental rights are safe. That was the perhaps impression. Now, by the time you came to Kesavan Bharati, look at the amendments. 24, 25, 26, and 29. 24th, they completely got over Golaknath. They said, how to amend, even fundamental rights can be amended. 25th was very important. And 31C, that was the only part which was struck down, which was said that a legislature can make a law. It can just put a declaration that this is to achieve directive principles. Once that declaration is made, like virtually 9th schedule, you can't question it. It's beyond judicial review. Then 26th was abolished privy purses and 29th was the Kerala reforms. Now, if you read Kesavan Bharati in full, the government actually won. They succeeded. 24th was upheld, 26th was remanded and upheld later, 29th was upheld, 25th upheld fully except that small part of 31C. So it was almost like an 85% victory for the government. But the basic structure tilted everything. And why the basic structure? Now look at how the Supreme Court. Now if you take the minority, all have gone by textual orientation, historical orientation. But look at Khanna. Khanna goes into structuralism. And see the next slide. Please see the next slide. Yes. The majority said the power to amend is not the power to destroy. You can amend it, but you can destroy it. And if you read some of the passages of Khanna, he says, look at 368 carefully. Read this section, article. It says the Constitution. It says this Constitution. I can amend the Constitution. I can amend this Constitution. So he says pre-amendment and post-amendment, the Constitution will continue. There will be a Constitution before the amendment, there will be a Constitution after the amendment. You must ask yourself the question. Post-amendment, what will remain? Will it be a Constitution at all? In other words, suppose hypothetically we accepted the minority view, we go back to the case, Shankari Prasad case, that everything can be amended. Suppose the government tomorrow simply removes entire part 3, removes 25 and 26. It's the same constitution. Are we a same democracy? Are we a republic? Answer is no. And that's why Khanna then evolved the basic feature theory. So basic feature theory was basically came across a multiple theories being put together, the structure of the constitution, how the amendment power is circulated, what is the interplay of fundamental rights, narrative principles, limitations on power, separation of power. All those things had a beautiful interplay, and you had. Now go to the minority view. They're equally well reasoned. Equally well reasoned. Take Justice Palekar's judgment, which I have cited. He makes a very interesting argument. He says that 368, read the text. There is no such limitation. Why are you reading into it? And he refers to Article 5, it should be Roman 5, Article 5 of the US Constitution. That has got similarity with 368. There also you can amend the Constitution by 2/3 majority in Congress. In Article 5 of the US Constitution, there is a limitation. You can't amend certain portions. So Palekar asked the question, Justice Palekar asked the question, if our makers, they obviously had the US Constitution before them, why didn't they add that in our Constitution? So that shows that they wanted to keep an unlimited power of amendment. Now, this is how the Kishan Bharati case took place. Now, please come to the next case, which I've just taken 3 or 4 cases